We will hear argument first this morning in Case 24-872, Hamm versus Smith. Mr. Overing.
Mr. Chief Justice, and may it please the Court. Nothing in the Eighth Amendment bars the sentence Joseph Smith received for murdering Dirk Van Dam nearly 30 years ago. Atkins created an exception for offenders known to be intellectually disabled, but Smith is not. He didn't come close to proving an IQ of 70 or below with scores of 75, 74, 72, 78, and 74. But the lower courts changed the rules. First, misreading Hall, they took the lowest score to represent a possibility that Smith's IQ is 69. Then, to the extent they considered other scores, they took each only in isolation and moved the line to 75. These maneuvers expanded Atkins, and this court should reverse that expansion. First, because it was not authorized by the Eighth Amendment. Second, because it would eliminate state discretion. And third, because it ignores that the combined effect of multiple IQ scores reduces error and yields a more accurate estimate. The answer to whether courts may consider the cumulative effect of multiple IQ scores is yes. The answer to how they handle multiple scores is not found in the Eighth Amendment and thus left to state discretion. Still, this court can offer some meaningful ground rules for how to handle multiple scores. First, states are allowed to make the first prong turn on the very best evidence of intellectual functioning, IQ. Second, states are allowed to define the requisite intellectual functioning as an IQ of 70 or below. Third, states are allowed to require the claimant to prove his IQ by a preponderance of the evidence. The court can then supply a durable rule of decision by which a state can adopt a reasonably reliable method for handling multiple IQ scores that when it suggests the offender's IQ is greater than 70, his sentence does not violate Atkins. Here, every identified method of handling multiple IQ scores favors the conclusion that Smith is not intellectually disabled. I welcome the court's questions.
How would you specifically handle the multiple scores here?
In this case, the consistent evidence is that Smith's IQ is above 70, and we've offered 5 different ways to see that, but we think ultimately it's Smith's burden to come with a method that proves that his IQ is likely below 70.
So what did is the test whether or not it is likely or is?
Likely below 70 is our understanding of the preponderance burden in Alabama. Other states are free to adopt other burdens of proof.
And what was the finding of the Court of Appeals and the District Court?
The sentence, Smith's IQ is below 70, doesn't appear in the District Court's opinion nor in the Court of Appeals' opinion. They found the first prong satisfied by a preponderance of evidence, but only after they changed the standard to be not just intellectual functioning, but not just IQ, but a broader conception of intellectual functioning.